In episode 13 of the Supreme Court Opinions Read podcast, I'll be reading the Supreme Court's opinion in Lackey v. Stinnie. The case was decided February 25th, 2025. And as always, we begin with the syllabus. Drivers whose licenses were suspended under a Virginia statute for failure to pay court fines sued the Commissioner of the Virginia Department of Motor Vehicles under 42 U.S.C. Section 1983, challenging the statute as unconstitutional. The district court granted a preliminary injunction prohibiting the commissioner from enforcing the statute. Before trial, the Virginia General Assembly repealed the statute and required reinstatement of licenses suspended under the law. The parties then agreed to dismiss the pending case as moot. Section 1988B allows an award of attorney's fees to prevailing parties under Section 1983. The district court declined to award attorney's fees to the drivers under that section on the ground that parties who obtain a preliminary injunction do not qualify as prevailing parties. A Fourth Circuit panel affirmed, but the Fourth Circuit reversed en banc. The en banc court held that some preliminary injunctions can provide lasting merits-based relief and qualify plaintiffs as prevailing parties, even if the case becomes moot before final judgment. Held. The plaintiff drivers here, who gained only preliminary injunctive relief before this action became moot, do not qualify as prevailing parties eligible for attorney's fees under Section 1988B because no court conclusively resolved their claims by granting enduring judicial relief on the merits that materially altered the legal relationship between the parties. Part A. Under the American rule, a prevailing litigant is ordinarily not entitled to collect attorney's fees from the loser absent express statutory authorization. Congress has provided that in actions brought under certain civil rights statutes, including 42 U.S.C. Section 1983, the court, in its discretion, may allow the prevailing party other than the United States a reasonable attorney's fee as part of the costs. To determine whether the drivers here qualify as prevailing parties under Section 1988B, the court begins with the statute's text. The court has recognized prevailing party as a legal term of art. When Section 1988B was adopted, contemporary dictionaries defined a prevailing party as one who successfully maintains its claim when the matter is finally resolved. Preliminary injunctions do not make a party prevailing because they do not conclusively decide the case on its merits. Such injunctions only determine if a plaintiff is likely to succeed along with factors such as irreparable harm, the balance of equities, and the public interest. The purpose of a preliminary injunction is to preserve the status quo until a trial can occur, and external events that render a dispute moot do not convert that temporary order into a conclusive adjudication. Part B. The court's precedents interpreting Section 1988B establish that a plaintiff prevails when a court grants enduring judicial relief that materially alters the legal relationship between the parties. Two recent decisions emphasize this change must be both judicially sanctioned and enduring. In Buchanan, the court rejected the catalyst theory, the theory that a plaintiff may receive attorney's fees under Section 1988B when he achieves the desired result because the lawsuit brought about a voluntary change in the defendant's conduct. The court explained that the plaintiff was not a prevailing party because there had been no judicially sanctioned change in the legal relationship between the parties. And in Soule v. Weiner, the court decided that a plaintiff initially granted a preliminary injunction after an abbreviated hearing, but denied a permanent injunction after an adjudication on the merits, did not qualify as a prevailing party within the meaning of Section 1988B because the plaintiff gained no enduring change in the legal relationship between herself and the defendants. The court's holding in this case that the enduring nature of that change must itself be judicially sanctioned follows naturally from Soule and Buchanan. A plaintiff who wins a transient victory on a preliminary injunction does not become a prevailing party simply because external events convert the transient victory into a lasting one. Part C. The rule established serves the interests of judicial economy. A straightforward, bright-line rule is easy to administer, reducing the risk of significant litigation over attorney's fees. Concerns that government defendants who have lost at the preliminary injunction stage will strategically moot litigation are speculative, and such a risk could arise in only a small number of contexts. The judicial role here is limited. Congress may amend the statutory language to empower courts to award attorneys' fees to plaintiffs who have enjoyed some success but have not prevailed in a judgment on the merits. Part D. The driver's remaining arguments are unpersuasive. The argument that Section 1988B was enacted against a historical backdrop that favored awarding interim costs at equity, including for preliminary injunctions, was rejected by the court in Alyeska Pipeline. The drivers also contend that availability of fees in some cases while litigation is ongoing suggests that Section 1988B includes no finality requirement, but the court's decisions simply indicate that attorneys' fees may be awarded when conclusive, enduring judicial relief is meted out on an incremental basis. Finally, the availability of fees under a court-ordered consent decree is consistent with the rule announced here. While the decree reflects the party's own resolution of the merits, it is approved and given force of law by a court, and it may grant enduring relief that materially alters the legal relationship between the parties. The dissent conflates preliminary judicial relief that becomes irreversible by way of mootness with relief that is permanent by virtue of a judicial order. Chief Justice Robert delivered the opinion of the court in which Justices Thomas, Alito, Kagan, Gorsuch, Kavanaugh, and Barrett joined. Respondents are Virginia drivers whose licenses were suspended due to their failure to pay court fines or costs. The drivers sued the Commissioner of the Virginia Department of Motor Vehicles under 42 U.S.C. Section 1983, arguing that the Virginia statute requiring suspension of their licenses was unconstitutional. The district court preliminarily enjoined the commissioner from enforcing the statute, but before the case reached final judgment, the Virginia General Assembly repealed the challenged law, rendering the action moot. The question presented is whether the drivers are prevailing parties who qualify for an award of attorney's fees under Section 1988B. Part 1. Until recently, a Virginia statute directed the state courts to suspend the license of any driver who failed to pay any fine, costs, forfeitures, restitution, or penalty lawfully assessed against him for violation of a federal, state, or local law. The suspension remained in force until the amount due was paid in full or the driver entered into a court-approved payment plan. Virginia drivers whose licenses were suspended under the law and who asserted that they could not afford to pay the fines or costs or keep up with a payment plan sued the Commissioner of the Virginia Department of Motor Vehicles on their own behalf and on behalf of a putative class. The drivers alleged that the statute facially violated the Due Process Clause by failing to provide sufficient notice or hearing to any driver before license suspension and violated both the Due Process and Equal Protection Clauses as applied to people who cannot afford to pay due to their modest financial circumstances. The drivers sought declaratory relief, preliminary and permanent injunction relief, and attorney's fees under 42 U.S.C. Section 1988B. In December 2018, the District Court granted a preliminary injunction prohibiting the Commissioner from enforcing the statute against the drivers or future class members. The court explained that the drivers had made a clear showing that they were likely to succeed on their procedural due process claim, though it noted they need not establish a certainty of success. The court also determined that the remaining preliminary injunction factors, the risk of irreparable harm, the balance of equities, and the public interest, weighed in the driver's favor. The Commissioner did not appeal the grant of the preliminary injunction. In April 2019, about 4 months before a bench trial was scheduled to begin, the Commissioner moved to dismiss as moot or, in the alternative, stay the case. The Virginia General Assembly had recently adopted Budget Amendment No. 33, which eliminated the suspension of driver's licenses for failure to pay court fines and costs through July 1, 2020, but did not repeal Section 46.2-395. The Commissioner represented that the General Assembly was likely to repeal the law during the next legislative session. The District Court granted a stay, reasoning in part that doing so served the interests of judicial economy and enabled the court to avoid weighing in on sensitive constitutional questions about license suspension schemes about which other courts had disagreed. In April 2020, the Virginia General Assembly repealed Section 46.2-395 and required the permanent reinstatement of licenses suspended under the law. As a result, the parties agreed that the action had become moot and stipulated to dismissal. The drivers, however, asserted that they were entitled to attorney's fees under Section 1988B, so the parties jointly requested that the court retain jurisdiction to resolve that dispute. The district court declined to award attorney's fees following Smith v. Rivero. In Smith, the Fourth Circuit held that a plaintiff awarded a preliminary injunction is not a prevailing party within the meaning of Section 1988B. A Fourth Circuit panel affirmed again relying on Smith. Judge Harris concurred, suggesting that the circuit may wish to reconsider that precedent. The Fourth Circuit did so, rehearing the case en banc and overturning its decision in Smith. It observed that Smith had become the outlier among the courts of appeals. It reasoned that some preliminary injunctions provide enduring merits-based relief that satisfies all the requirements of the prevailing party standard. And it explained, in light of this court's decision in Winter v. Natural Resources Defense Council, that a plaintiff could no longer prevail on a preliminary injunction for reasons that had virtually nothing to do with the merits of her claim. Finally, it noted that Congress had enacted Section 1988B in the interest of facilitating the redress of civil rights grievances. The en banc court articulated a new standard. When a preliminary injunction provides the plaintiff concrete, irreversible relief on the merits of her claim and becomes moot before final judgment because no further court-ordered assistance proves necessary, the subsequent mootness of the case does not preclude an award of attorney's fees. Applying that standard, the en banc court vacated and remanded the case to allow the district court to determine a reasonable fee. Judge Quattlebaum dissented, arguing that a preliminary injunction does not constitute a judicial decision on the merits and that a fee award on the basis of such an injunction therefore conflicts with both the text of Section 1988B and this court's precedents. We granted certiorari to determine whether the term prevailing party in Section 1988B encompasses a party who is awarded a preliminary injunction if the case becomes moot before the court reaches a final judgment. Part 2. Since 1796, this court has maintained that the judiciary itself would not create a general rule independent of any statute allowing awards of attorney's fees in federal courts. The principle that the prevailing litigant is ordinarily not entitled to collect a reasonable attorney's fee from the loser became known as the American rule. Federal courts may depart from this rule only when there is express statutory authorization to do so. In 1976, Congress adopted the Civil Rights Attorneys' Fees Awards Act. The law provides that, in actions brought under certain civil rights statutes, including 42 U.S.C. Section 1983, the court, in its discretion, may allow the prevailing party other than the United States a reasonable attorney's fee as part of the costs. The question is whether the drivers in this case qualify as prevailing parties within the meaning of Section 1988B. Section A. When interpreting a statute, we begin with the text. As we have previously recognized, the phrase prevailing party in Section 1988B is a legal term of art. We assume that when Congress borrows terms of art in which are accumulated the legal tradition and meaning of centuries of practice, it presumably knows and adopts the cluster of ideas that were attached to each borrowed word. At the time Section 1988B was adopted, Black's Law Dictionary defined prevailing party as the party who successfully prosecutes the action or successfully defends against it. It explained that prevailing party status does not depend on the degree of success at different stages of the suit, but whether at the end of the suit or other proceeding, the party who has made a claim against the other has successfully maintained it. The prevailing party, in other words, is the party ultimately prevailing when the matter is finally set at rest. Preliminary injunctions, however, do not conclusively resolve legal disputes. In awarding preliminary injunctions, courts determine if a plaintiff is likely to succeed on the merits, along with the risk of irreparable harm, the balance of equities, and the public interest. The purpose of a preliminary injunction is merely to preserve the relative positions of the parties until a trial on the merits can be held. and to balance the equities as the litigation moves forward. Crafting a preliminary injunction is an exercise of discretion and judgment, often dependent as much on the equities of a given case as the substance of the legal issues it presents. Such relief is also customarily granted on the basis of procedures that are less formal and evidence that is less complete than in a trial on the merits. As a result, we have previously cautioned against improperly equating likelihood of success with success and treating preliminary injunctions as tantamount to decisions on the underlying merits. The transient nature of preliminary injunctions is most apparent when a court reaches a different conclusion upon full consideration of the merits. For example, in one of our more recent cases interpreting Section 1988, Soule v. Weiner, protesters sought a preliminary injunction against a state regulation of beach attire in order to assemble nude in the form of a peace sign. The day after the complaint was filed, the district court held a hearing and granted the preliminary injunction. The preliminary injunction permitted the protest to occur and thus preserved the participants' rights until a final determination could be made on the merits of their claim. Ultimately, however, the court declined to award a permanent injunction, ruling that the regulation was no more burdensome than necessary to protect the public. Because preliminary injunctions do not conclusively resolve the rights of parties on the merits, they do not confer prevailing party status. A plaintiff who secures a preliminary injunction has achieved only temporary success at an intermediary stage of the suit. It cannot yet be said that he will ultimately prevail when the matter is finally set at rest, or that he will have successfully maintained his claim at the end. And external events that render a dispute moot do not convert a temporary order designed to preserve the status of the parties into a conclusive adjudication of their rights. The Fourth Circuit en banc was persuaded that Winter's stringent merits requirement avoided the risk that a plaintiff may prevail and thus be entitled to fees based on a preliminary injunction that had virtually nothing to do with the merits of her claim. But it is not enough that Winter guarantees a preliminary injunction award has at least something to do with the merits. The plaintiff must succeed on the merits. Section B. This conclusion is consistent with our precedents interpreting Section 1988b. We have held that, for the purposes of Section 1988b, a plaintiff prevails when a court grants enduring judicial relief that constitutes a material alteration of the legal relationship of the parties. For example, we have ruled that a plaintiff may qualify as a prevailing party based on an award of nominal damages, or a final victory on a material even if not predominant claim. By contrast, a party does not qualify as a prevailing party when a court of appeals overturns directed verdicts and discovery orders entered against him, or when a court enters a declaratory judgment but does not modify the defendant's behavior towards the plaintiff. Two of our more recent decisions highlight the requirements that the change in legal relationship be judicially sanctioned and enduring. In Buchanan Board and Care Home, Inc. versus West Virginia Department of Health and Human Resources, we rejected the catalyst theory, the theory that a plaintiff may receive attorney's fees under Section 1988b when he achieves the desired result because the lawsuit brought about a voluntary change in the defendant's conduct. In that context, we explained that the plaintiff was not a prevailing party because there had been no judicially sanctioned change in the legal relationship of the parties. The defendant's voluntary actions lacked the necessary judicial imprimatur. We were not persuaded that Section 1988b authorizes federal courts to award attorney's fees to a plaintiff who filed a potentially meritless lawsuit and reached the sought-after destination without obtaining any judicial relief. In Soule v. Weiner, we decided that a plaintiff who gained a preliminary injunction after an abbreviated hearing but was denied a permanent injunction after a dispositive adjudication on the merits did not qualify as a prevailing party within the meaning of Section 1988b. That plaintiff, we explained, gained no enduring change in the legal relationship between herself and the defendants. Although we left open the question presented in this case, we described the plaintiff's success at the preliminary injunction stage as a transient victory at the threshold of an action, a fleeting success that did not establish that the plaintiff had prevailed on the gravamen of her plea for injunctive relief, one tentative in character in view of the continuation of the litigation to definitively resolve the controversy. We recognize that neither opinion resolves this case, but our holding today follows naturally from these precedents. In Seoul, we established that the change in the legal relationship between the parties must be enduring. In Buchanan, we established that the change must be judicially sanctioned. Today, we established that the enduring nature of that change must itself be judicially sanctioned. A plaintiff who wins a transient victory on a preliminary injunction does not become a prevailing party simply because external events convert the transient victory into a lasting one. Rather, a plaintiff prevails under the statute when a court conclusively resolves a claim by granting enduring judicial relief on the merits that materially alters the legal relationship between the parties. Footnote 1. A different body of case law addresses when a defendant is a prevailing party for the purposes of other fee-shifting statutes. Our decision today should not be read to affect our previous holding that a defendant need not obtain a favorable judgment on the merits to prevail, nor to address the question we left open of whether a defendant must obtain a preclusive judgment in order to prevail. As we have explained, plaintiffs and defendants come to court with different objectives. Carrying on. Section C. The rule we establish today also serves the interests of judicial economy. A straightforward, bright-line rule is easy to administer, reducing the risk of a second major litigation over attorney's fees. The drivers, however, suggest that our rule promotes simplicity at the cost of creating perverse incentives. They fear that government defendants who have lost at the preliminary injunction stage will strategically moot litigation rather than risk a fee award were they to ultimately lose on the merits. We found similar concerns to be entirely speculative when we rejected the catalyst theory in Buchanan. We reiterate that such risk could arise in only a small number of contexts. After all, if a plaintiff has a cause of action for damages, a defendant's change in conduct will not moot the case. And even if the plaintiff seeks only injunctive relief, voluntary cessation of the challenged conduct does not moot an action unless it is absolutely clear that the allegedly wrongful behavior could not reasonably be expected to recur. A survey asking public interest organizations to self-report on the impact of Buchanan does not change our minds. It is Congress's job to craft policy and ours to interpret the words that codify it. Atextual judicial supplementation is particularly inappropriate when Congress has shown that it knows how to adopt the omitted language or provision. Congress has shown that it knows how to empower courts to award attorney's fees to plaintiffs who have enjoyed some success but have not prevailed in a judgment on the merits. In the Freedom of Information Act, for example, Congress authorized courts to assess attorney's fees when a complainant has substantially prevailed, even if through a voluntary or unilateral change in position by the agency. 5 U.S.C. Section 552A(4)(e). If Congress determines that the rule we adopt today is unwise, it may amend the statutory language just as it enacted Section 1988B itself in response to our decision in Alaska Pipeline Service versus Wilderness Society. Until then, it is of course our job to apply faithfully the law Congress has written. Section D. The drivers urge the opposite conclusion, but we find their arguments unpersuasive. First, the drivers joined by the dissent argue that the dictionary definitions support them, but they assume that the favorable resolution of a dispute is tantamount to success on a claim in a legal action. A prevailing party, however, is defined in the latter sense, one who successfully prosecutes the action, who has made a claim against another and has successfully maintained it. Second, the drivers and dissent contend that Section 1988B was enacted against a historical backdrop that favored awarding interim costs at equity, including for preliminary injunctions. The dissent in Alaska Pipeline similarly invoked the well-established power of federal equity courts to award attorney's fees when the interests of justice so require. We rejected that argument, however, and determining that the American rule supplied the default rule at law and equity, subject to narrow historical exceptions not at issue here. Next, the drivers argue that the availability of fees while litigation is ongoing suggests that Section 1988B includes no finality requirement. The dissent likewise points to our statement in Buchanan that a prevailing party is not intended to be limited to the victor only after entry of a final judgment following a full trial on the merits. We have recognized that Congress contemplated the award of fees pendente lite in some cases. For example, we have explained that in school desegregation cases, many final orders may issue in the course of the litigation because injunctive relief must prove its efficacy over a period of time and often with frequent modifications. Our decisions simply indicate that attorneys' fees may be awarded when conclusive, enduring judicial relief is meted out on an incremental basis. Key language on which the dissent relies, our statement that a party prevails when it succeeds on any significant claim affording it some of the relief sought, including relief on the merits pendente lite, explained our rejection of the central issue test, which would have required a party to prevail on its central claim in order to be awarded attorney's fees. It did not refer to preliminary relief. The availability of fees following the entry of a court-ordered consent decree is fully consistent with the rule we announced today. A consent decree reflects the party's own resolution of the merits, but it is approved and given force of law by the court. Violation of a consent decree is enforceable by a citation for contempt. So a consent decree is like a final judgment in the relevant ways. It conclusively resolves the claim, bears a judicial imprimatur, and may grant enduring relief that materially alters the legal relationship between the parties. That is why we have only awarded attorney's fees where the plaintiff has received a judgment on the merits or obtained a court-ordered consent decree. For its part, the dissent conflates preliminary judicial relief that becomes irreversible by way of mootness with relief that is permanent by virtue of a judicial order. That a preliminary order may sometimes function like a final order due to external circumstances is not dispositive of the nature of the order. Section 1988b permits courts to award attorney's fees to a prevailing party. A party prevails when a court conclusively resolves his claim by granting enduring relief on the merits that alters the legal relationship between the parties. Critically, both the change in relationship and its permanence must result from a judicial order. A preliminary injunction which temporarily preserves the parties' litigation positions based in part on a prediction of the likelihood of success on the merits does not render a plaintiff a prevailing party, nor do external events that moot the action and prevent the court from conclusively adjudicating the claim. Because the drivers in the present case gained only preliminary injunctive relief before this action became moot, they do not qualify as prevailing parties eligible for attorney's fees under Section 1988b. The judgment of the Court of Appeals for the Fourth Circuit is reversed and the case is remanded for further proceedings consistent with this opinion. It is so ordered. Justice Jackson, with whom Justice Sotomayor joins, dissenting. Congress has authorized courts to award attorney's fees to the prevailing party in certain civil rights cases. 42 U.S.C. Section 1988b. Today, the court holds that a plaintiff who secures a preliminary injunction does not prevail under this fee-shifting statute, even when the preliminary injunction provides meaningful relief and is never reversed on the merits. The court maintains that this holding follows naturally from our precedents. But that will come as a surprise to the 11 courts of appeals that have previously considered this issue. All of them agree that at least some preliminary injunctions trigger fee eligibility under Section 1988b. Stated simply, the majority's categorical preclusion of fee awards for any plaintiff who successfully obtains preliminary injunctive relief is unwarranted. It lacks any basis in the text of Section 1988b and is plainly inconsistent with that statutory provision's clear objective, which is to encourage attorneys to file civil rights actions on behalf of the most vulnerable people in our society. The court has now eliminated fee eligibility for all preliminary injunctions, even those that effectively resolve the case. But if Congress had meant for prevailing party status to hinge entirely on the conclusive nature of a judicial order, it could easily have said so. It is the role of Congress, not this court, to weigh concerns about administrative ease against the benefits of guaranteeing individuals an opportunity to vindicate their civil rights. There is no persuasive reason to believe that Congress meant to preclude fee awards for every plaintiff who secures preliminary injunctive relief, but not a final judgment, no matter the context. Therefore, I respectfully dissent. Part 1, Section A. Nothing in Section 1988B's text compels the conclusion that a plaintiff who obtains preliminary injunctive relief is never eligible for a fee award. Section 1988B states simply that in actions to enforce certain civil rights statutes, including 42 U.S.C. Section 1983, the court in its discretion may allow the prevailing party other than the United States a reasonable attorney's fee as part of the costs. The majority recognizes that prevailing party is a legal term of art and begins its analysis by asserting that this term means what legal dictionaries said it meant at the time that Section 1988B was enacted. According to the majority's preferred dictionary, a prevailing party is one who successfully prosecutes the action or successfully defends against it. Thus, prevailing party status turns on whether at the end of the suit or other proceeding, the party who has made a claim against the other has successfully maintained it. Reasoning from this definition, the majority holds that preliminary injunctions which provide interim relief by their nature can never confer prevailing party status because they do not conclusively resolve the rights of parties on the merits. But the majority's analysis inexplicably conflates the requirement for success when the suit ends, which is what the dictionary definition says, with a requirement that the suit end by virtue of a conclusive judicial proceeding on the merits of the plaintiff's claims, which is nowhere in Black's Law Dictionary or anywhere else. In other words, the majority's reasoning elides the fact that a suit can end in various ways, including through acts of the defendant or others that moot the legal action. Black's Law Dictionary and its contemporaries simply require a court determining eligibility for a fee award to take stock of where things stand at the end of the lawsuit. A prevailing party for Section 1988B purposes is one who has successfully maintained his claim in the manner I described below, see Part 2A, when the matter is finally at rest. In essence, then, the majority errs by assuming that the only kind of resolution to a suit that can precipitate a fee award is a conclusive final judgment on the merits. That assumption is unfounded. The text of the fee statute does not require a final judgment in the party's favor, conclusive or otherwise, nor does any dictionary definition of prevailing party to which the majority cites. Rather, according to Black's Law Dictionary, a prevailing party is simply a party to a suit who successfully prosecutes the action or successfully defends against it, prevailing on the main issue even though not to the extent of his original contention. Ballantyne's Law Dictionary is substantially similar. It defines prevailing party as the party who is successful or partially successful in an action so as to be entitled to costs. Significantly, for present purposes, both dictionaries further emphasize that to be a prevailing party does not depend upon the degree of success at different stages of the suit, but whether at the end of the suit the party who has made a claim against the other has successfully maintained it. Yet today the majority demands that in order to prevail, the party must have achieved a certain degree of success at a certain point in the case, a conclusive final judgment in his favor at the end of litigation. Section B. This court has not previously linked prevailing party status to securing a conclusive final judgment. Quite to the contrary, we have held that a prevailing party for fee-shifting purposes is one who has succeeded on any significant claim affording it some of the relief sought, either pendente lite, i.e., pending the suit, or at the conclusion of the litigation. That is, a plaintiff prevails when he accomplishes his lawsuit's objective, which is to achieve a material alteration in the legal relationship between the parties. This is because, for a plaintiff, at the end of the rainbow lies not a judgment, but some action or cessation of action by the defendant that the judgment produces, the payment of damages, or some specific performance, or the termination of some conduct. A plaintiff who secures a preliminary injunction awarding actual relief on the merits of his claim that is never reversed by a final decision of the court has successfully maintained his claim at the end. Such a plaintiff has achieved what he has come to court for, the desired alteration of the legal relationship between the parties. Footnote 1. There are, of course, other kinds of preliminary injunctive orders, including orders that maintain the status quo. All that is necessary to reject the majority's categorical rule is the recognition that at least some preliminary injunctions afford the type of material change that confers a prevailing party status. Take this case, for example. At the point it ended, when the district court dismissed the litigation as moot, respondents had secured a preliminary injunction against the Commissioner of the Virginia Department of Motor Vehicles. That order enabled respondents to drive their cars on Virginia's highways for 16 months over the Commissioner's objection. And because the district court's interim award had facilitated respondents' access to the road as licensed drivers, they had prevailed on the merits of their claim in every meaningful sense. Put another way, at the end of the litigation, respondents did not leave the courthouse empty-handed. Instead, they departed having accomplished exactly what they had sought to achieve. The fact that respondents achieved their goal via a preliminary court ruling as opposed to a final judgment is irrelevant, for nothing in the language of Section 1988 conditions the district court's power to award fees on full litigation of the issues or on a judicial determination that the plaintiff's rights have been violated. Juxtapose that reality with the text of other statutes that make prevailing party status expressly dependent on the entry of a final order. For example, the Emergency School Aid Act of 1972, enacted just 4 years before Section 1988b, states that, upon the entry of a final order, a court hearing a school desegregation case may allow the prevailing party other than the United States a reasonable attorney's fee as part of the costs. 20 U.S.C. Section 1617, repealed 1979. Several statutes enacted after Section 1988b are similarly explicit about when a fee award must be fastened to a final judgment. The fact that Section 1988b lacks any such language confirms that a conclusive ruling from the court in the form of a final judgment is not a prerequisite for a fee award under that statute. Section C. The majority disregards these important context clues and focuses instead on a provision of the Freedom of Information Act that authorizes fee awards for a complainant who has substantially prevailed by obtaining relief through either 1. A judicial order or an enforceable written agreement or consent decree, or 2. A voluntary or unilateral change in position by the agency. 5 U.S.C. Section 552A4E. The term prevailing party appears nowhere in this FOIA provision. But no matter, the majority nevertheless suggests that this is how Congress authorizes fee shifting for plaintiffs who have enjoyed some success but have not prevailed in a judgment on the merits. The problem is that Congress had a much more targeted objective when it enacted Section 552A4E. It sought merely to repudiate this court's decision in Buchanan Board and Care Home, Inc. versus West Virginia Department of Health and Human Resources, which had held that a plaintiff must obtain some judicial relief to be eligible for a fee award in FOIA cases. Footnote 2. Congress enacted 5 U.S.C. Section 552A4E because Buchanan had empowered government agencies to stonewall valid FOIA claims and then prevent an award of attorney's fees by disclosing the documents at the last moment before judgment, thereby mooting the case. Under Buchanan, such plaintiffs were not eligible for fee awards because they had not obtained any judicial order, preliminary, final, or otherwise. This strategic behavior ensured that FOIA plaintiffs never became eligible for fee awards despite incurring significant costs, so Congress intervened. Carrying on. Since the point of Section 552A4E was to abrogate the rule of Buchanan in the FOIA context and revive the possibility of FOIA fee awards in the absence of a court decree, that statutory provision sheds no light whatsoever on whether the term prevailing party requires a plaintiff to secure a conclusive ruling on the merits to qualify as a prevailing party for purposes of Section 1988b. In short, while the majority insists that obtaining a preliminary injunction can never suffice for a fee award under Section 1988b, because preliminary injunctions do not conclusively resolve the rights of parties on the merits, the text of Section 1988b, contemporary dictionary definitions, and our precedents require far less. All of the courts of appeals to consider the question, 11 in total, understood this and thus correctly held that for fee-shifting purposes it is possible for a party to prevail based on a preliminary ruling. Footnote 3. This is just a bunch of citations to circuit court opinions holding as much, and so I'm not going to read them all out. Carrying on. The majority's reading of prevailing party in Section 1988b makes obtaining a court's conclusive final judgment the hallmark of that status in a manner that is both novel and in many ways anathema to the legal term of art that Congress actually chose. Part 2, Section A. So what does it take to qualify as a prevailing party for purposes of this fee-shifting statute? In Farrar v. Hobby, we explained that a plaintiff prevails if he receives 1. Actual relief on the merits of his claim in a manner that 2. Materially alters the legal relationship between the parties by modifying the defendant's behavior in a way that directly benefits the plaintiff. This test is well established, and it leads inextricably to the conclusion that in some circumstances, an unreversed preliminary injunction can confer prevailing party status. Start with the requirement of a material alteration of the legal relationship of the parties, which we have repeatedly called the touchstone of the prevailing party inquiry. A plaintiff need not obtain all of the relief he has requested in the lawsuit to satisfy the requirement. Instead, under our precedents, a plaintiff who has achieved even some of the benefit he sought has secured the change in the parties' legal relationship necessary to cross the threshold to a fee award of some kind. A permanent injunction, just like a declaratory judgment or damages award, will usually satisfy that test, because permanent injunctive relief generally affects the behavior of the defendant toward the plaintiff. At least some preliminary injunctions also qualify. The preliminary injunction in this case, for example, provided respondents with actual relief by reinstating their suspended licenses, allowing them to drive without fear of sanction for failing to repay their fines and fees. For the roughly 16 months that the preliminary injunction was in place, that ruling worked the requisite material alteration in the parties' relationship by permitting respondents to engage in conduct that would have been prohibited otherwise. It is indisputable that the preliminary injunction the district court issued provided a direct benefit to respondents. That relief was also awarded on the merits. We have long taken a practical approach to the merits inquiry in this context. Under that approach, relief is granted on the merits when it provides a resolution of the dispute which changes the legal relationship between the plaintiff and the defendant. Notably, for prevailing party status, we have not required that a court actually determine whether a legal claim is meritorious. The majority acknowledges our ruling that the entry of a consent decree following the party's own resolution of the merits counts. Indeed, in Mar, we upheld a fee award based on a consent decree that did not purport to adjudicate the plaintiff's claims at all. We have also suggested that default judgments, which do not involve any assessment of the merits of the plaintiff's claims, almost invariably give rise to fee awards. A court's entry of a preliminary injunction, which does require a judge to make a preliminary assessment of the merits, provides a basis for prevailing party status that is at least as strong as a consent decree or a default judgment. Plaintiffs seeking the extraordinary remedy of a preliminary injunction must make a clear showing that they are likely to succeed on the merits, and the court's decision to order preliminary injunctive relief often requires searching proceedings, even though the evidence is less complete than in a trial on the merits. In this case, the district court thoroughly addressed the merits of respondents' claims and granted their request for preliminary injunctive relief after extensive briefing and an evidentiary hearing during which multiple witnesses testified. It blinks reality to suggest that the district court's order requiring the commissioner to give respondents their licenses back now, based on the court's conclusion that respondents were likely to succeed if this matter proceeded to trial, is not the stuff of which legal victories are made. It is no answer to simply declare, by ipse dixit, that preliminary injunctions are materially different from consent decrees because a consent decree is like a final judgment in the relevant ways, i.e., it conclusively resolves the claim, bears a judicial imprimatur, and may grant enduring relief that materially alters the legal relationship between the parties. The very question before us is the relevance of this kind of finality to the prevailing party determination, and luckily that question has already been answered. Neither the text of Section 1988B nor any of this court's past cases make fee eligibility dependent on the entry of a conclusive final judgment, as I explained above. In any event, if a plaintiff need only obtain an order that is like a final judgment to prevail, it is not at all clear why at least some preliminary injunctions would not count. Consider, for example, a dispute in which the district court reviews the evidence and the parties' arguments and enters the type of preliminary injunction that changes the legal relationship between the parties. The case proceeds, but then becomes moot such that the litigation ends, the preliminary injunction is not and can never be reversed by a subsequent order of the court. In this scenario, all the purportedly relevant characteristics of a consent decree exist, because the parties' legal relationship was materially altered by judicial imprimatur, and that preliminary relief is conclusive insofar as the case has ended and the ruling cannot be undone by a later determination. In this circumstance, the preliminary injunction functions much like the grant of an irreversible partial summary judgment on the merits, which all appear to agree would suffice to confer fee eligibility under Section 1988B. Section B. Our decisions in Buchanan and Soule are not to the contrary. The majority cites these two decisions to support its view that obtaining a preliminary injunction is never sufficient to qualify the recipient for a fee award under Section 1988B, but those cases hold no such thing. Instead, they simply clarify that for a plaintiff to prevail, the requisite change in the legal relationship of the parties must be both judicially sanctioned and enduring. Neither case mandates the majority's categorical rule. In Buchanan, this court rejected the so-called catalyst theory, under which a plaintiff could collect a fee award as a prevailing party without securing any judicial relief so long as the lawsuit produced a voluntary change in the defendant's conduct. We held that such a voluntary change, although perhaps accomplishing what the plaintiff sought to achieve by the lawsuit, lacks the necessary judicial imprimatur on the change to trigger fee eligibility. In Soule, we considered whether a plaintiff who obtains a preliminary injunction but is subsequently denied a permanent one prevails for fee purposes under Section 1988B. We explained that when a plaintiff's initial victory at the preliminary injunction stage is superseded by a non-favorable final ruling on the merits, he does not qualify as a prevailing party because the relief he received was not enduring. A preliminary injunction that mandates a judicially sanctioned legal change in the parties' relationship and is never reversed by a final ruling on the merits satisfies both Buchanan and Soule. A court that issues interim injunctive relief unquestionably gives its judicial imprimatur to the change afforded, as Buchanan requires. For its part, Soule stands merely for the proposition that a party can be divested of prevailing party status if his success rested on a premise the district court ultimately rejected. But Soule is an apposite when a subsequent final decision does not thwart the judge-sanctioned basis for the preliminary injunction. Indeed, Soule expressly said so by specifically reserving the question whether, in the absence of a final decision on the merits of a claim for permanent injunctive relief, success in gaining a preliminary injunction may sometimes warrant an award of counsel fees, the precise issue that is before the court today. The majority thus overreads our precedents to support its blanket rule that preliminary injunctions can never support fee awards. With respect to Soule in particular, it is true that we characterize the preliminary injunction at issue there as fleeting and tentative, but the Soule court did not tie the requirement for enduring relief to the inherent permanence of the relevant judicial order. Instead, we made crystal clear that of controlling importance to our decision was the fact that the eventual ruling on the merits for defendants, after both sides considered the case fit for final adjudication, superseded the preliminary ruling. At the end of the day, Soule should be taken to mean only what it expressly holds. Preliminary injunctive relief that is subsequently superseded by a final judgment reversing the ruling does not endure for fee-shifting purposes. Here, the preliminary injunction provided actual relief to the respondents for more than 16 months, and there was no Soule-like supplanting of that preliminary relief by a subsequent court order. Part 3, Section A. In addition to misinterpreting the text of Section 1988B and misconstruing our precedents, the majority ignores Congress's clear intent to expand access to justice. It is puzzling, to say the least, that the majority seems to go out of its way to adopt a rule that categorically prohibits fee shifting while interpreting a statute that expressly authorizes fee awards. There is no dispute that Congress enacted Section 1988B for a specific purpose, to respond to this court's decision in Alyeska Pipeline Service Company v. Wilderness Society, which had rejected the former equitable practice of awarding attorney's fees to the prevailing party in certain civil rights cases. The Alyeska court held that absent statutory authorization, courts should not depart from the American rule under which litigants ordinarily bear their own attorney's fees. Congress swiftly enacted Section 1988B in Alyeska's wake, to codify a civil rights exception to the American rule. The majority does not and cannot dispute that Congress's intent was to ensure effective access to the judicial process for persons with civil rights grievances. Consistent with that clear congressional intent, this court has previously recognized that fee awards should be available to partially prevailing civil rights plaintiffs. This principle is, in fact, readily apparent from the statute's enactment history. The history demonstrates that the question of awarding fees for success based on interim orders was not overlooked by the legislature. To the contrary, Congress specifically contemplated the award of fees pendente lite, at least where a party has established his entitlement to some relief on the merits of his claims. The majority says that Congress merely wanted Section 1988B to authorize fee awards when conclusive enduring judicial relief is meted out on an incremental basis. But that is not what the historical record establishes, and Buchanan flatly rejects this contention. There, we specifically observed that, per Section 1988B's legislative history, prevailing party is not intended to be limited to the victor only after entry of a final judgment following a full trial on the merits. The legislative history is likewise unequivocal that a prevailing party for Section 1988B purposes should also include a litigant who succeeds even if the case is concluded prior to a full evidentiary hearing before a judge or jury. Section B. Nor could a Congress that wished to authorize fee awards for civil rights victories have intended the absurdities that will result from the majority's categorical preclusion of preliminary injunctive relief from Section 1988B. To state the obvious, the majority's bright-line rule lacks the nuance that is needed to account for the various circumstances in which a preliminary injunction may be preliminary in name only. One example is the plaintiff who requests a preliminary injunction to achieve an interim result given the time frame at issue. When protesters seek an injunction to exercise their First Amendment rights at a specific time and place, say to demonstrate at a Saturday parade, a preliminary injunction will give them all the court-ordered relief they need, and the end of the parade will moot the case. Thus, the courts of appeals regularly hold that plaintiffs who successfully obtain a preliminary injunction that permits them to engage in the otherwise prohibited conduct prevail for fee-shifting purposes. In its rush to carve preliminary injunctions out of Section 1988B, the majority also overlooks situations in which courts have, in fact, conclusively resolved the merits of a plaintiff's claims at the preliminary injunction stage. A trial court might definitively determine that a law is facially unconstitutional in the course of granting preliminary relief, for example. But the majority nonetheless adopts a sweeping rule under which preliminary injunctions can never be the basis for fee eligibility. And to what end? The majority seeks to justify its broad holding on the grounds that it discourages fee disputes and thereby serves the interests of judicial economy. But concerns about judicial administration cannot supplant Congress's clear intent to promote access to justice via fee shifting in civil rights cases. What is more, it is actually the majority's categorical rule that will promote wasteful litigation and incentivize litigants to manipulate fee liability. Under the majority's rule, a plaintiff who has incurred substantial attorney's fees in order to secure a preliminary injunction that provides all the relief he needs will face a choice. He may either concede that the litigation has run its course and pay his own fees, or he may seek to litigate the case to final judgment in order to secure a fee award. No one would blame a plaintiff with a strong case for choosing the latter option, but such additional litigation is an inefficient waste of judicial resources if the plaintiff has already achieved his objective at an earlier part of the case. Worse still, the majority's rule appears to preference conservation of judicial resources over the maintenance of meritorious civil rights lawsuits to the extent that excluding preliminary injunctive relief from Section 1988B facilitates the strategic mooting of cases by defendants to avoid paying attorney's fees. This case illustrates precisely that problem. After a robust evidentiary hearing, the district court issued a comprehensive opinion that preliminarily enjoined the commissioner from enforcing the challenged law against respondents. Seeing the writing on the wall, the commissioner sought and obtained a stay of the case over respondents' objections based on his representation that the legislature was likely to repeal the challenged law. The commissioner then successfully lobbied the legislature to repeal the legislation, emphasizing that doing so would, in his words, result in respondents' pending litigation being dismissed, relieving the department from continuing to incur costly legal fees. As the Fourth Circuit observed, precluding fee shifting in this scenario is manifestly inequitable because it leaves respondents holding the bag for considerable litigation fees despite, and largely because of, their having succeeded in obtaining preliminary relief. Ironically, it was the strength of respondents' challenge as verified by the court's preliminary order that prompted both the change in law and the commissioner's robust effort to stiff the plaintiffs with respect to attorneys' fees. Moreover, it is hardly a revelation that lawyers would otherwise be willing to litigate meritorious civil rights cases, i.e., matters in which interim relief is critical due to ongoing civil rights violations, will likely be discouraged from taking on such representations if fee awards can so easily be thwarted. The majority dismisses concerns about strategic mooting as both entirely speculative and likely to arise in only a small number of contexts. But as I have shown, the facts of this very case belie the majority's nonchalance, particularly in light of the Buchanan experience. Research suggests that the court's rejection of the catalyst theory in that case had the predictable practical effect of discouraging public interest organizations and private attorneys from taking on civil rights actions. Similarly, a multitude of legal advocacy groups have filed amicus briefs in this case to explain that losing the ability to recoup fees for securing interim relief will jeopardize their missions. There is thus every reason to believe that the net result of today's decision will be less civil rights enforcement in the long run. Without irony, the majority reads a statute that was enacted to ensure that private citizens have a meaningful opportunity to vindicate their civil rights, as if Congress meant to make private civil rights enforcement harder to achieve. The majority holds that obtaining a preliminary injunction never entitles a plaintiff to fees under Section 1988B. In doing so, it overrules the decision of every court of appeals to consider the issue, relies on an atextual conclusive judgment requirement, and ignores both our precedents and Congress's intent. It is quite true that Congress has demonstrated its ability to fix our mistakes in this realm, but in my view, rather than relying on Congress to check our work, we should give full effect to the plain text and remedial purpose of Section 1988B in the first instance. This court should have held that when a court hearing a civil rights lawsuit issues a preliminary injunction that materially alters the relationship between the parties and is never reversed, the requesting party prevails for fee-shifting purposes and is thus eligible for a fee award under Section 1988B. And that is it for the opinions in this case. I don't know. I don't think that I have a very strong view on who has this issue right, to be perfectly honest. As I've said before, I don't know who's right on the precedent because I haven't read the relevant precedents. And as I've said before, it's not always clear what the Supreme Court's precedents, what propositions the Supreme Court precedents stand for on, a specific issue. And you're very much relying on the justices to summarize these or, cite them in a way that isn't selective or dishonest. So yeah, I don't know who's right on the precedent. I don't really care who's right on the legislative history because I don't really care about legislative history. I think Jackson and Sotomayor, just the liberal justices generally are wrong to want to look at legislative history. It's not a good or reliable indicator of what the text of a law actually means, and that's where the inquiry should really begin and end, is the text of the law. And if that's ambiguous, then we look to what the law meant as originally, as originally understood. And yeah, the legislative history is just not a good or reliable indicator of that, in my opinion. Anyway, I'm also not really concerned about who's right as to the practical effects. What would this do for incentives for bringing civil rights litigation and judicial economy and whatnot? I don't care about who's right as to the practical consequences. That doesn't tell me what the law actually means. And then as to the actual textual analysis, saying, okay, well, let's look at what this term prevailing party this term of art prevailing party meant at the time. They're looking at legal dictionaries, and yeah, I'm not entirely sure who's right there either, to be honest. I do think the dictionary definitions tend to favor the majority. The dissent kind of seems to want to read them for a very, like, I don't know, like, practical or pragmatic view of, like, what prevailing party means, that, like, oh, well, so long as they have successfully defended their claim, in that they have gotten what they came to court to get, practically gotten what they came to court to get, oh, well, I'm able to drive, so, for practical purposes, I got what I came to court to get. And so long as they've retained or gotten that by the time the litigation ends, however it happens to end, whether it's mooted out or whatever, then that's the prevailing party. I don't think the definitions really support that all that strongly. The dictionary definitions really support that all that strongly. And it would seem odd for the term prevailing party, referring to the party that is prevailing in a lawsuit before a court, for that term to be, or for that status to sometimes depend on events that are completely external to, to the court and to the lawsuit, and very, like, practical concerns of, like, oh, well, I've gotten what I came to court to get. It's like, okay, you might get what you come to court to, to get, in a very practical sense, but that doesn't mean you've won on the legal issues. And one would think that prevailing party refers to the person who prevails on the legal issues, given the context that it's being used in. We're using this in the context of a lawsuit before a court, deciding these legal issues brought before it. So I don't know. Yeah, that's the closest I can give to, much of an opinion at all about who is right on this. Is, to my mind, the dictionary definitions seem to somewhat favor the majority over the dissent, and the rest of it I honestly don't really care about all that much, and I don't think should have all that much weight in determining what the statutory text means. Anyway, with all of that said, if I may ask you, my friends on the other side of the screen, please like, share, comment, follow the podcast wherever you happen to follow podcasts, and if you'd like to support the show, you can do so on Patreon. The main content of the show will, of course, always remain free, but Patreon members have access to episodes early and to any bonus or exclusive content, and they can request specific content including other than reading Supreme Court opinions. With that, tune in for the next episode, where we will continue through the Supreme Court's 2024 term. Until then.